Hello friends, in the series on the income tax cases, today we will discuss a very important judgment of Bombay High Court in a writ petition. The name of the judgment is Underwater Services Company Limited, SAMSON Maritime Limited versus Assistant Commissioner of Income Tax. This case has been reported in 448 ITR at page number 691 and the date of the judgment is 21st October 2021. This case is regarding the issue of notices under section 153A to the assessee after the search is being made on the assessee under section 132 or requisition is made under section 132A. Friends, in these cases, whenever the search is made on the assessee, it is the ritual or it is the mandate of the law, you can say, that the notices for the 6 years to be issued to the assessee for completing the assessment under section 153A. In the notice, it is written that the assessee has to file the income tax return. But when the notice is being issued, generally it has been seen that in the almost all cases, that in that notice it is not told to the assessee that what incriminating material the assessee has collected in the search or in the requisition, or what statements the department is going to rely in the assessment. Whenever the assessee makes the request to the department for these incriminating material, the copy of this incriminating material, the department generally gives the answer that you have to first file the return and then we will provide the material. So the question is that whether this material is to be provided before filing the return of income by the assessee under section 153A or after filing the return. This was the moot question in this writ petition. The court said that the assessee has already filed its return of income, and now you have again issued the notice to him to file the return of income. If the assessee will not be knowing that what seized material is with the department or what seized material the department is relying on, then how the assessee will file his revised return under section 153A? If you are not providing the material to him, then he will not be aware of the facts or the documents which are available with the department. So in this case, the assessee has no option just to file the return already filed by the assessee under section 139. So according to the Bombay High Court, issuing notice under section 153A without providing him to the copy of the seized material, it is a futile exercise and it cannot be the mandate of the law, because the copy of the returns is already with the department which has been filed by the assessee under section 139. So if you are telling him or asking him to file the return without the copy of the seized material being provided to him, then it is next to impossible for the assessee to file the return under section 153A. So in this case, Bombay High Court quashed the notice under section 153A issued to the assessee and directed the department to fresh issue the notice under section 153A by providing all the necessary incriminating material to the assessee. Friends, following the same analogy, we can say that this law can be applied to the section 153C notices also, and side by side in section 148 notices also. Because if we see section 148, in that case also the assessee has already filed his return of income in maximum number of cases. If you are not telling him the reasons for reopening the case, then how he will file his revised return? It is but natural that the return which the assessee has already filed will be repeated by the assessee. So this cannot be the intention of the law to just give a burden on the assessee to refile its return of income. The Bombay High Court also said that the return is already available with the department. So if the assessee will again file the return, then it will not solve any purpose. So it is the mandate of the law that whenever you are issuing the notice under section 153A to the assessee, you have to provide the copy of the seized material to the assessee, or you have to tell in the notice under section 153A what is the seized material available with the department. Friends, at the end of this video, once again I am repeating the name of the case. The name of the case is Underwater Services Company Limited, SAMSON Maritime Limited versus Assistant Commissioner of Income Tax, and this case has been reported in 448 ITR at page number 691. Thank you, friends.